Spencer Thomas. This case is on de novo review from a summary judgment entered in favor of 7-Eleven and franchisees in a case that arose in Lee County, Fort Myers area. On March 12, 2019, Spencer Thomas was at the cash register.
Yeah, I think Mr. Leach, we have a good handle on the facts.
All right.
Let me start off with a question. When we're looking at establishing a duty to protect, we're looking at reasonably foreseeable occurrences. Is that fair?
It's a threshold issue of foreseeability. There's going back to Paul's graph from law school, we all remember that foreseeability has duty elements to it, and it also has proximate causation elements to it, which
Absolutely
sometimes can cause a little bit of confusion. The duty element of the foreseeability analysis is just a threshold look, just looking kind of as a general proposition, whether in the context of this case, vehicular traffic and pedestrians is the type of a generalized danger that people should be required to take precautions with regard to.
But if you look at foreseeability in that context, as I understand it, this is not a little sports car. This is an SUV that comes running into the parking lot, speedily runs up to the curb, jumps 6 inches, goes across 3 feet of sidewalk, crashes through the window, hits your client, ends up in the back of the store. Is that a reasonable, foreseeable occurrence to which the duty to protect against that would arise?
Well, we have to look at it. Obviously, the duty element is a question of law, but there are requirements in determining the legal duty. You have to also look sometimes at make a factual inquiry and see what the actual facts are. The main case on this, which actually came out of the second district, the Hammond case, and then went to the Supreme Court. In the Hammond case, it dealt with an issue where a vehicle hit somebody as he was exiting the Hardee's in that case. And looking at the factual inquiry, the Springtree case that first arose on appeal to this court, Judge Blue said, look, we have a situation where we have vehicular traffic and we have pedestrians. That's the type of general foreseeable type of harm where you have a duty to take precautions. So he easily determined that there was clearly a duty under those facts. And then that was appealed to the Supreme Court, or review was sought in the Supreme Court. The Supreme Court accepted review. And the Supreme Court said, well, there's clearly a duty here under these circumstances, because as in McCain, we have power lines, we have people digging, creates a foreseeable area. But in this particular case, though, let's take a look at it from the proximate causation element. So the Springtree case, even though it was on appeal on the issue of duty, ultimately the court determined that that duty and proximate cause were met in that particular case. And in this case,
but those cases pre-McCain sort of make a distinction between what I'll call outside the premises and inside the premises. Is that fair?
That is clearly true. The Schatz case, the Jones case, yes.
And then McCain comes out, and you're saying that changes the landscape.
It changes the landscape, but also, we're not in the horse and buggy era anymore. Schatz was decided in the early 60s when, vehicles weren't, obviously there were vehicles at the time. I'm not trying to suggest that there weren't, but it wasn't the type of a problem where you could have this situation where a car could barrel into a building in the same way that you do more and more recent years when cars are more powerful and bigger.
What's interesting, and your case has forced me to look for bollards everywhere I go. And nobody briefed it, so I'm assuming nobody found or didn't think it was worthwhile to raise any issues about codes or best design practices or anything like that.
Well, it's interesting you should ask that, Your Honor. When the defendant moved for summary judgment, they said there's a bright line rule. All you have to do is look inside, outside. So the only thing they relied upon in their summary judgment was the complaint where we alleged that he was inside the store, Mr. Spencer Thomas's deposition where he said he was inside the store, and the deposition of their client who said, well, what her client said that they cited was that we couldn't have put up bollards because, did you see the video? If this guy barrels through like that, he obviously wouldn't have been stopped by a couple of bollards because because of the nature of things. But of course, this particular franchisee owns another 7-Eleven, which has bollards all right out in front of it, which he didn't have a really good explanation for that, except to say, well, those were there when I bought the store. But getting to your question.
Well, I know at this particular store, I think it was a video or something, as I understand this, there was a bollard, but that is by the gas tank.
There's a bollard on the side.
The propane tank.
Yeah, yes. If you can, those gas tanks that you use to barbecue on the weekend, there were bollards next to that, but there wasn't.
But that's an easier case to imagine where a car running into a rack of propane tanks is something that, it's on a different qualitative basis than somebody running an SUV through a 6-foot, curb, 3 feet of sidewalk and all the way to the back of the store.
This is what I would say about that. There's a parking spot right in front of the store, right in front of the glass entryway to the store where the vehicle went through. On the side, that's not a parking area. That's an area where you can go pick up a barbecue tank if you want, but it's not set up so that there's a parking spot right there in front of it where if you happen to lose control or you miss the brake for the accelerator, you go zooming right through that. It was a very big SUV that just went boom right through the middle of the store. And in this particular case, the Springtree case makes it clear that you have to look at the totality of the circumstances. There's no one thing. There's no per se rules. That's the one thing that's extremely clear from the Supreme Court's decision in Springtree. There's no per se rules. You got to look at the totality of the circumstances. And in this case, in response to the summary judgment that was filed by 7-Eleven, we filed an affidavit from a nationally known expert with regard to these types of issues who has a database, and the database clearly reflects that 1.3 times per day on average, 7-Eleven stores are hit by this exact type of an incident where a vehicle goes through into the store and injures somebody.
Am I correct? His 1.3 of going into a store, those incidents go back. I think he referred to 3 incidents that go back into the 90s. Am I correct?
Let me make sure we understand. 1.3 times per day nationally.
Nationally, right.
Now, what he did was when the trial judge seemed to say, well, where's the stuff on Florida? Now, it did say Florida in the original affidavit, but then what he did is he went and he did specific analysis of Florida, Lee County, and Fort Myers.
Right.
And he determined that 3 times in 1991, 1992, and 1995, there were 7-Elevens in Lee County that had gotten hit in this manner. And it wasn't specific as to whether it was this particular store. And I guess this franchisee would say, well, I wasn't owning it at the time. But, it's important to remember, we have 2 defendants here. We have a franchisee and we have 7-Eleven. If 7-Eleven certainly has actual knowledge of the danger of these types of accidents happening. No doubt about it. In fact, if you take a look, there's a 4th district case from 1988 in which the court quoted from the risk manager for 7-Eleven saying, well, we know that these things are a problem and we're trying to take care of them. And the court said, well, that's sufficient. That shows you have actual constructive notice of this type of problem. And therefore, summary judgment would be inappropriate in that case. In this case, but if you get to the summary judgment stage, it seems to me you're talking about the proximate causation issue as opposed to duty. Well, ultimately, I think that you're right. There's no issue about duty here. There is, if you take a look at Judge Blue's decision in the Hammond case before it went up to the Supreme Court, he clearly stated in there, quoting McCain and going through the simple analysis of McCain, saying there's clearly a duty here. Based on our reading of McCain, if I could just briefly read one sentence, we note that the trial court erred by granting summary judgment on the threshold issue of foreseeability.
Well, I love Judge Blue, but I got to listen to what the Supreme said.
Well, no, I agree. The Supreme Court approved your court's decision in that case, but what the Supreme Court then said is, well, you affirmed on the basis of duty. Well, clearly there's a duty here. We don't have any fault with that. What we think they were talking about in the trial court, perhaps, is the foreseeability as it relates to the proximate causation issue, and therefore we're going to talk about it from that perspective. So in the Supreme Court's decision in Springtree, they actually kind of went beyond what Judge Blue had said in his decision in this court and said, well, we're going to analyze it both. The duty is, there's no question about that. That's completely off the table. That's easy. That's easy as pie. We were going to talk about from proximate cause, which is exactly then what they did. And they said there's no per se rules. You have to look at everything on a case by case basis. And taking a look at the totality of the circumstances, they talked about why Schatz was that. They basically said that case is limited to its specific facts. Jones, same type of a thing. We have to look at the specific facts. In this case, the distinguishing characteristic that shows, which is one of the three general bases you use to show a duty under these circumstances and proximate cause, frankly, is if they knew or should have known about the dangerous condition. If they knew or should have known that this type of a problem was happening on a national basis. And in the case of the local franchisee, if they either knew that it happened on the local basis, or they should have known based upon the fact that it was happening, and they have statistics and reports that show it. And the statistics that the expert relied upon are, as Rule 90.704 says, the types of facts or data that are reasonably relied upon by experts in the subject to support an opinion expressed, even if those facts might not be admissible in evidence. Ultimately, to get the specific incidents from 91, 92, and 95 into evidence, we're going to have to show maybe some kind of a hearsay exception to get those specific things in, maybe something from a newspaper article or something that would fit within a hearsay exception. But as a general proposition, the evidence in this record is clear that the defendant, 7-Eleven, had actual notice of this exact type of problem. Vehicles crashing through the front glass entryways of their stores and hitting pedestrians or people who are on the inside or people who are on the way out, exiting the store. And taking a look at it from that case by case, factually specific basis, the evidence in this case is sufficient for a jury determination as to the issue of foreseeability in the proximate cause context. And again, the duty context is really a no-brainer. It's clear as a bell. And Judge Blue, all you have to do is look at Judge Blue's decision and then see where the Supreme Court says, yeah, that's easy. We're not even going to talk about that. Taking a look at the answer brief, the defendant tries to claim that actually the decision in that case supports them because the court said, well, there's no duty issue in this particular case. They said there was no duty issue because there was a duty. There was clearly a duty. They said there wasn't a duty issue because it wasn't even something that was even in debate or contested. The other main issue that the defendants rely upon in their answer brief is they try to pick apart the affidavit of Mr. Ryder and try to claim that this court should not consider it or should disregard what it says. It's important to remember the affidavits were both properly before the trial court. If they wanted to move to strike it, they could have had that heard. If they wanted to depose Mr. Ryder, they could have done that. In this case, they didn't do any of that stuff. The only thing they relied upon in their summary judgment was the idea that there's an indoor-outdoor dichotomy. And under this indoor-outdoor dichotomy, if it happens inside the store, there's a per se rule, and that's it. And we say Schatz says that from 1961. We say Jones says that from 1984. And they say Graham says that. Now, Graham is the interesting case. That's the one involving the Steak and Shake from 1996. So that would have been after McCain, but before Springtree. And that case is interesting because if you read the opinion, and there's a very spirited defense from Judge Sharp there, by the way, which I thought was very well analyzed and argued. But and it's in his dissent where this becomes clear. The plaintiff in that case did not introduce evidence of other incidents of a similar nature happening at other Steak and Shake stores. Now, it's probably common sense that if it's happening at 7-Elevens all over the place, that it's probably happening at Steak and Shakes as well. But in that case, that was a deficiency in the evidence. And in that case, also the defendant introduced evidence showing that there was no code violations and all that stuff. So that case,
but
really
in this case, Mr. Leach, even after McCain, I think I saw some cases in the brief, maybe from the fourth and or the fifth TCA, that still seem to hold to this inside-outside dichotomy.
The inside-outside dichotomy is something that is one factor that you look at. Again, you have to look at all the factors. There's no per se rules. That's the one clear signal from Springtree. In the fourth district case that I think you're referring to, in that case, there was no record of that having ever happened. It was considered something so bizarre. It was some cabanas set up And there had never been any type of an issue with these cabanas being hit in the past prior. So the court said, well, there's no knew or should have known in that case. Whereas again, in this case, we have clear knew or should have known. And the other case that I think Your Honor is referring to is the one I just mentioned, the Graham case, which involved the Steak and Shake. In that case, again, there was no evidence that Steak and Shake knew or should have known about the dangerous, about the possibility of this type of incident happening, because because no evidence was introduced to prove that in this case.
Mr. Leach, excuse me for interrupting. You're just looking at my clock. You're into your rebuttal time, but feel free to use the time as you wish.
With all respect, Your Honor, I'll reserve the balance of my time and turn it over to Mr. DeLugo.
Okay, very good. Thank you, Mr. Leach. You'll still have your 5 minutes for rebuttal. Okay, Mr. DeLugo.
May it please the court, my name is Michael DeLugo from the law firm of Wicker Smith in Orlando, and I represent 7-Eleven and the franchisees. And with all due respect to Mr. Leach's argument, where he says duty is not an issue, duty is the issue. And the indoor-outdoor dichotomy still exists even after McCain, even after Springtree Properties, because it's Springtree Properties, the court specifically stated, in cases where an injury occurred outside the entrance or exit of a store or business, as was the case here, the courts have found that summary judgment is inappropriate. Well, Mr. Thomas was inside the 7-Eleven, and every case that has examined this issue over the years, going back to 1961 in Schatz, which was also a 7-Eleven case, courts have held that there is no duty as a matter of law. And it's a question of law for the court to decide. And if the Schatz court stated, we are unaware of any ordinance, statute, or rule of law, and none has been cited by the parties to this appeal, which requires that the owner of a store erect a barrier between the entrance to his establishment and a street, highway, or parking area sufficient in height and strength to prevent motor vehicles negligently operated by others from entering the store where customers are usually present.
Well, Mr. DeLugo, if we look at this zone of risk that someone creates, maybe this is more a policy issue than a legal issue, but how many times does somebody have to jump the curb and go through the front door before a duty arises to take some protections in front of the store?
I mean, it's a question of law. I'm not sure that there is a number. I mean, I would argue that, you know, it just doesn't happen with a sufficient frequency for there to be a duty that arises under these circumstances. And the courts have repeatedly found that in cases in which the vehicle makes contact with a patron outside of the store, then that is a jury issue and is not amenable to summary judgment. But the cases in which a vehicle actually goes into the store and strikes a patron in the store, that those cases, the store, 7-Eleven in this case, Steak and Shake in the Graham case, that they do not have a duty to prevent or to take actions to prevent a vehicle from entering the store, because it's such an anomalous situation. It's so rare that it's not something that a store owner should have to do. And there's no recognition under Florida law that would require taking such a precaution. And that case is that has been the issue in Schatz. That was reiterated by the first DCA in the Krispy Kreme case versus Cornett, where they simply said that the defendant did not owe a duty as an insurer of the patron's safety while in the premises in question. The same distinction was drawn by this court in Jones versus Dowdy, saying that this case is virtually identical to Schatz. Well, this case, Mr. Thomas's case, is identical to Schatz as well, even to the point where it involves 7-Eleven. The Graham court, that's the Steak and Shake case, said that in order to impose a duty on Steak and Shake, Langley's driving into the Steak and Shake must have been reasonably foreseeable, not just possible. And so it's not, it has to be reasonably foreseeable. And one way to establish foreseeability is to show that a specific incident occurs with such frequency that it may be expected to happen again, thus suggesting that the defendant reasonably needed to take steps to avoid or prevent the incident. But vehicles driving into stores
let's take your line of analysis. So the SUV jumps the curb, goes through the sidewalk, hits a patron just coming out of the store, hits the patron. The SUV continues inside, strikes somebody at the upfront cash register. There's a duty owed to the person who just came out the door. There's no duty owed to the person who's standing inside the store.
That's correct.
All right.
I would absolutely make that distinction. And the courts have repeatedly made that distinction, that if someone's coming out, if someone's on the outside, someone gets pinned against a telephone booth on the outside, or a public telephone on the outside of the store, then that creates a jury issue. If someone's in the store, such as Mr. Thomas, who was just standing at the register, 7-Eleven does not owe a duty under those circumstances. And as far as Mr. Ryder's declarations, the court properly rejected those. And Mr. Ryder, as an expert, can't tell the court what duty is. That is a matter of law for the court to decide. And the court here correctly decided that 7-Eleven did not owe a duty under the facts of this case. There were no disputed issues as to any material facts. Mr. Thomas testified that he was inside the store when he was contacted by the SUV. So this is such an anomalous set of circumstances that, as a matter of law, 7-Eleven cannot have a duty to protect individuals in the store from being hit by vehicles that are driven negligently into the store. And unless the court has any further questions, I'm going to rely on the contents of our brief.
Okay.
Thank you.
Thank you, Mr. DeLugo.
Your Honor, may it please the court.
Hold on a minute there, Mr. Leach. I'm trying to play with the clock. Hold on.
Sorry.
Go ahead, sir.
I really thought your hypothetical was very on point. I mean, that's the kind of thing a law professor would come up with. You have a person who's just exited the store, he gets hit and then is driven in, and there's a difference in the way and whether there's a duty to one or a duty to the other. The hypothetical I was thinking of, which is not as good, honestly, but I liked it, was, let's say for 10 days in a row, somebody goes through and hits and it goes into the store and creates an injury to somebody in the store. It happens 10 days in a row. Each day they rebuild the glass front, and then the 11th day, the plaintiff goes in, and same thing happens to him. Now, clearly, this has happened 10 days in a row. Even the most absent-minded franchisee would know we have a problem here. And certainly 7-Eleven, who already knows, because as I've said, they get 1.3 of these a day, would know. But under those circumstances, if Mr. DeLugo's theory is correct, his per se bright line rule, there would be no duty under those circumstances, even though, as you said, how many times does this have to happen before they really know? The only evidence as to the frequency of these types of issues is not the argument of counsel, which he says it's so rare, it's so anomalous. The only evidence of that comes from the declaration of Mr. Ryder. And Mr. Ryder's declaration is crystal clear, 1.3 times on average a day. This happens at 7-Eleven stores. So this is by no means something that's rare and anomalous. And in fact, if you watch the local news, I can't think of the number of times, particularly since this case came along, I've been thinking about them more often when I see them. But it seems rather common that you have incidents where somebody mistakes the brake for the accelerator and runs into a store or runs into a building or runs into somebody's house or something like that. This is not something that's the rare type of thing that in 1961 might have been like something that was just extraordinary and nobody's ever heard of it. It happens all the time. We have evidence that we've introduced through Mr. Ryder that shows that it does happen all the time. And that evidence is
But his 1.3 per day is spread out over a nationwide base of perhaps thousands of 7-Elevens.
That's correct. That is correct. Yes, that's
Okay.
nationally. But he did in his supplemental affidavit, he did bring it down to Florida and talk about Florida cases. And I think if you want, I can take a look through here and find it. But I believe he said in Florida there were more than 40 incidents where patrons were injured inside of or at the entrance of such stores. So, 40. I mean, the reality is 7-Eleven has actual knowledge of this.
But that's not particularly helpful unless I know the breakdown, because by saying inside or outside, I'm still playing with this inside-outside dichotomy.
Well, it says inside of or at the entrance of a convenience store. That's what the declaration says. It says in the Florida records there were more than 40 incidents where patrons were injured inside of or at the entrance of a convenience store. That's what it says in the declaration. Now, again, their summary judgment was based on the deposition of Mr. Thomas saying I'm inside. the complaint which says I'm inside, and their client who said if the bollards wouldn't have stopped them, even though I had the bollards at the other store. So that's the only evidence they're relying on. We have this affidavit that shows that if you take a look at kind of the factual inquiry that you sometimes make in a duty analysis, this is not something that where there is not the generalized foreseeable zone of risk between pedestrians and vehicles in which a crash would be considered bizarre or extraordinary or something that just you would never expect to happen. So in this case, in the posture of this case, which is on appeal from a summary judgment on the issue of duty, there's clearly this is clearly a situation where the lower court erred. I should also, in conclusion, if I could, I'd like to point out that in the trial court's analysis, what the trial court said was, well, I like the affidavit from Mr. Ryder. It might create a situation where a case go to jury, but you don't have proof in this case that there was a crash into this specific store or into the franchisee's other store, and that is specifically not permitted under the Springtree case. The Springtree case harmonized all the other cases, including Schatz and Jones. But the one case that it disapproved was the Molinares case. And in the Molinares case, which is the 3rd District case, the court had held, well, there'd never been an incident on this property where a vehicle had gone into the store. Therefore, there's no duty under those circumstances. And the Florida Supreme Court said the fact that no prior, and I'm quoting now, the fact that no prior similar accidents occurred at the exact same location in Molinares was not determinative of whether summary judgment should have been granted. The absence of a history of similar accidents does not necessarily relieve a defendant business of a duty to erect bumpers, guardrails, or warning signs. The defendant business may have constructive knowledge of similar accidents at similar locations. Constructive knowledge of these accidents may be sufficient to establish foreseeability. That's the beginning and the end right there. The analysis that
Mr. Leach, you're going to have to wrap it up for us, please.
The analysis the trial court engaged in was clearly incorrect, even under an abuse of discretion standard. We have a de novo standard here. The trial court erred. I respectfully request that the court reverse the summary judgment and remand for trial on the merits.
Thank you, Mr. Leach. Thank you both. Very well argued. You can exit our virtual courtroom.